The concept of negligence is a big part of our legal system, but even with a clear definition of the word, it is not always clear how negligence will play out in court. In today's Injuries Are Personal with Reynolds Law, attorney Carl Reynolds is here to explain. And I don't admit this often, but I found this very confusing. So you brought it up in regards to a case that you're working on right now. So
correct. Put
this scenario out there for us.
All right, so we have a scenario where our client has the right-of-way, okay? No question she has the right-of-way, and the driver of the other vehicle is attempting to turn left, okay? The vehicle turns left in front of our vehicle, and then because of traffic ahead, stops right across, leaving her no time or space, and a T-bone accident occurs.
Okay.
The vehicle turning left received a citation, as they should have. Unfortunately, in court, you are not allowed to bring in the citation as evidence, okay? You could bring in the statute that our client has a right-of-way and left-turning vehicles have the duty to yield, but you can't bring in the fact that a police officer wrote a citation for a moving violation because the police officer is not the judge, jury, and executioner and did not witness it. They're basing it on basically hearsay evidence, circumstantial evidence, and so the citation and the police report, the accident report, cannot be brought into evidence because, again, those are hearsay statements and basically judgments made by the investigating police officer.
All right, so what do you use if you can't use tickets, and do you have to chase down witnesses?
Yes, and so that's the frustrating part. So often when I interview a potential jury panel and they want to know, well, where's the police report? Who got a ticket?
Right.
And the problem is we can't tell them. We can't say what the police report is not allowed to be produced to them, and who got a ticket isn't allowed to be presented to them. So unfortunately what happens is, in a clear case like that where there's clear liability, which I have in that case, my client didn't think to interview witnesses, to get information from witnesses and things. It was pretty clear cut. Now they're trying to make this other story saying that she was going too fast or she wasn't paying attention. None of that is substantiated by the evidence, mind you, but they're making those arguments and they're not paying full value, and here we are. We're going to have to be brought to court and have a jury of her peers make the decision. So
where does the negligence part come in? How do we determine if the left turner was negligent or if the straight client was negligent?
So negligence is defined by the rules of court, basically the jury instructions, that it's what a reasonable person would have done under similar circumstances or would not have done under circumstances. So negligence is not doing something a reasonable person would have done or doing something a reasonable person wouldn't have done.
So in this case, would the reasonable person have made that left turn in front of the car?
Correct. And then there's also legal cause. So negligence is one thing, but then you also have to make sure that negligence is the legal cause of the injury. And what that means is, but for that negligent action, would the accident have happened, okay? So let's use this example. Let's say, and this isn't germane to our case, she was not driving under the influence, but let's say you went to a restaurant, you had one too many, you're probably a little tipsy, but you're driving, quote unquote, safely, nothing uncareful. You're stopped at a stoplight, okay, and you're rear-ended, okay? You're guilty of a moving violation. You're guilty of actually breaking the law, and you might get arrested, but you are not negligent in causing the crash.
Right.
Just because you're guilty of drinking and driving, it was the person that hit you from behind. Well, in this instance, if she was driving a couple miles over the speed limit perhaps or whatever, it was the action of the vehicle turning left that was the cause of the crash, not her. You know, if this vehicle never turned left, if she was going 2 miles over the speed limit, the accident still never would have occurred. It's
and if
the
she
left
was 5 miles under the speed limit and that vehicle turned left, she might have still hit him.
Exactly.
And that's probably what you're trying to prove.
Exactly.
Oh, well, that sounds nice and complicated. No wonder you have a tough job.
It's tough, and when we're in accidents, obviously you make sure you're okay and get the medical treatment you need, but also do secure witnesses and also get legal help if there's going to be an issue sooner rather than later, because we can canvass the area for any video, that sort of thing that helps prove the case.
And I think that's the big takeaway.
Right, because the cop citation and the police report isn't going to be admissible in court.
And that's the one thing I learned from this whole discussion is citations don't hold anything in court for you, and that if you are unfortunately involved in any type of accident, get a lot of information on the spot, because
Correct.
you never know what you're going to need.
And involve a lawyer so they can help do the investigation as well, because a lot of times you're worried about hospital bills, getting your car fixed, all that kind of stuff, and we can help.
And let's be honest, that was all confusing, so I'm glad it isn't for you. For more information about any of your legal questions, Carl and his team are certainly able to dig for answers. You can go to injuriesarepersonal.com. We'll be right back.